last matter to come before the court this morning is MTGLQ Investors LP versus Loretta Wagner et al. Each party will have 15 minutes in which to present the case. If you're the appellate, if you wish to retain some of that time for rebuttal, let me know when you come up to the podium. I'm keeping track of the clock and we'll keep you apprised of the passage of time. We are being visually and audibly recorded and being posted online, so please try to remain by the podium as much as possible. We have reviewed your briefs and we're ready to proceed with the order.
I can reserve 4 minutes for rebuttal.
Thank you. I'll do one of these when you get close to 4 minutes.
Thank you, and good morning. My name is Thomas Delventhal, and I am representing the appellants Loretta and Robert Wagner. This is a foreclosure matter, and the Wagners were defendants in this foreclosure matter. And the Wagners are object to the trial court rendering a decision on a complaint that was brought by a party that did not have standing. They're already bringing 2 issues here. One is that the court was wrong when it issued its decision for foreclosure on a complaint that was brought by a party without standing, and then also that the court refused to address this jurisdictional issue of standing. It just swept it away. And it's the Wagner's position that the court had an obligation to address that issue. And that issue is the very issue that we're here today presenting before the court. Fannie Mae brought this action initially, and at that time they had standing. That's not an issue here. But what happened after that is that Fannie Mae then transferred the note and the mortgage to MTGLQ. Now, after they did that, 2 months later, they come into court and they amend the complaint. They amend the complaint and they add a count for reformation of the mortgage. Now, their initial complaint would not stand on its own. They discovered that there was an error in the legal description and they had to amend the complaint. So they come to the court, even though after they've assigned the note and mortgage to MTGLQ, and they amend the complaint, they added a count for reformation.
Does Civil Rule 25C, you want to address that?
25C?
Sure.
Yes. The 25C is the appellees basically rely on 25C to resolve this case. And their reliance on that is misplaced. They say in their brief that we never referred to 25C in our brief, and they also say that in BK Builders, which the appellants rely on, is the 5th District case, which is directly on point with this case. They say that they didn't rely on it, they didn't mention 25C either. And I'd say that also that on Schwarzwald, what this case is also based on, I'm sure that the court has some familiarity with, Schwarzwald doesn't mention 25C either. Well, why is that? It's because 25C doesn't apply here. 25C is a rule on process of substitution. It does not obviate the standing issue, which the appellees seem to want to assert. If a party brings a motion for substitution of a party under 25C, the court still has to make the inquiry of standing. Presumably, that when a party brings a motion for under 25C, they're going to bring some evidence that this proposed substituted party does have standing. In this case, in a mortgage case, that the mortgage and note has actually been assigned to this party. And if a moving party does not have any evidence to establish standing, presumably the court would deny the motion to substitute the party. And so the 25C is just inapplicable here. And the appellee's argument is basically they make one single argument, and it is entirely reliant on 25C. And they premise their argument is outlined under the heading, an action may be prosecuted by the original party even after a transfer of interest. And relying on 25C, that basically says that that's true. Well, that's just wrong. In fact, the law is the opposite. It said an action may not be prosecuted by an original party after a transfer of interest. After you transfer the interest...
Which rule says that?
Pardon me?
Which rule says that?
That's the holding in Schwartzwald. And Schwartzwald is quite clear on this, that you have to have standing in order to bring a foreclosure complaint. Is that once you lose interest in the matter, when you get rid of this, when you sign the note in the mortgage, you no longer have standing anymore. You no longer are an injured party. You have to have an injury in order to have standing.
Well, then wouldn't that change the language of 25C?
Well, 25C again is a matter of process. It does not address the issue of standing. It does not obviate the
But
issue
the
of standing.
underlying whole issue then would be standing. So if you're gonna transfer an interest, then you're arguing that the second you transfer that interest, you no longer have standing.
That's correct.
But then the next part of that sentence says the action may be continued by or against the original party. So
But
if the action may be continued by the original party,
Well,
but you're saying that would mean that you don't have standing, so then this rule's kind of messed up.
well, I mean, the rule again it's a rule of procedure and process. It does not obviate the standing issue. The standing issue the standing still has to be determined on
Would
process.
that be in the initial complaint before it was transferred, before the interest was transferred?
The standing was asserted in the initial complaint, and standing was also asserted in the second amended complaint, which I might add is that when Fannie Mae filed the second amended complaint, and they asserted in there that they were the party that was able to enforce the mortgage, that was manifestly untrue at that case. It was manifestly untrue because at the time that they filed the second amended complaint, they also filed an amended preliminary judicial report. Now, if you look in the amended secondary judicial report, it'll show in there that Fannie Mae has signed the note in the mortgage, or the mortgage, to MTGLQ. And so when they filed that second amended complaint, and they said that we could enforce the mortgage, that was not true. They did not have standing. And the amended and preliminary judicial report that they filed with that showed that. But nonetheless, MTGLQ was not substituted in until a month later. Now, I think that, it's to revisit the Schwartzwald case, is that, the Schwartzwald was a mortgage case, mortgage foreclosure also. And the holding there is quite clear. It says that the standing is required to invoke the jurisdiction of the court, and the lack of standing cannot be cured by substitution of the real party in interest. When Fannie Mae brought the second amended complaint, they didn't have standing. They then later substituted MTGLQ in. That didn't cure the standing issue.
Wasn't Schwartzwald, though, talking about requiring the holder of the note in the mortgage to establish standing at the commencement of the foreclosure, which they did in this case?
They did, but standing is always before the court, has jurisdiction. Standing is related to jurisdiction, and the court's
So you're
jurisdiction to
extending
hear that particular case.
So you want us to extend Schwartzwald?
I think
Beyond-
this case basically is Schwartzwald.
Well, they're talking about having the right to, being a holder of the note mortgage at the commencement of the case in Schwartzwald, is my reading of it.
Well, in the commencement of the case, but also I would argue that the case commenced at the time they filed a second amended complaint. Is that, that the issue of standing has to be again determined there, and it was pleaded in the second amended complaint that they asserted that they had standing, as they had to do, as anybody has to do. I guess I can I think that the practical aspect of the ruling in Schwartzwald, I think, will make this clear, is that Schwartzwald says that before you get into the courthouse door, you have to have standing. That you have to be the injured party. It goes to justiciability and the jurisdiction of the court. The court's jurisdiction is based on justiciability. And justiciability is that the parties have to have an interest in the matter. They have to be the injured party. You can't be somebody without interest in the matter and walk into the court. You have to have standing.
So
And
are you suggesting then that at the moment Fannie Mae transferred, there was, and the subsequent party, MTGLQ, hadn't filed anything yet, there was a brief moment in time where this case was not even effective anymore then, because there was no injured party, because these guys divested themselves of interest when they transferred, and these guys hadn't filed a complaint yet. So you're saying at that point in time, there was not even a case?
That's true. I mean, the court did not have before it a plaintiff that had standing. MTGLQ had been substituted in at that point, and Fannie Mae no longer has standing. I mean, Fannie Mae at that point was no different than somebody just walking down Main Street at that point. I mean, anybody cannot walk into court and amend a complaint. You have to have standing. You have to have an injury. You have to have an interest in the matter. And not anybody can just walk into the court and just pick a case and amend a complaint. You have to have an interest in that case. And what Fannie Mae did in this case is that's exactly what they did. They had no interest in this case at the time they filed the second amended complaint. They were like anybody else walking up Main Street and just walk into court and amended the complaint. They had no interest.
Anybody walking down Main Street hadn't filed the initial complaint, though.
Yes, but again, as the court in BK Builders states is that the amended complaint replaces the initial complaint. And even so here, because the original complaint, unlike what the appellees argue in their brief, is that the original complaint could have proceeded anyway. Notwithstanding the holding of BK Builders, is that even if you apply BK Builders, well, the original complaint could have proceeded anyway. And I contend that that's not the case.
You have 3.5 minutes.
Okay. And just to wind up then, is that their case failed initially because the complaint they initially filed was defective, because they had to come to the court and reform the mortgage. They couldn't proceed on their initial complaint. They had to come back and amend and ask the court for the equitable remedy of reforming the mortgage. And so the second complaint really did replace the first complaint, because the first complaint they couldn't proceed on. And so when it came in the second time and added an account for reformation, they had to have standing when they did that. And they didn't have standing. And the court was erred when they issued a judgment on it. What the court should have done, and what Shortwell says, the court could only do one thing, was dismiss the complaint. And what should have been done here is that MTGLQ, after they got assignment of the note, in that 2-month period, is come in and make an appearance, and under Rule 25C, motion to be substituted in for the plaintiff. That's what should have happened. I mean, arguably, if you look at Shortwell, you look at the dicta and the reference to the Sixth Circuit Court, in the Zurich case, they mentioned that if you don't have standing, you don't even have standing to substitute a party. And so, arguably, in this case, that Fannie Mae didn't have standing to substitute MTGLQ in because they didn't have standing. They didn't have standing to do anything in this case, let alone file an amended complaint. And you can argue that MTGLQ still isn't in this case properly because they weren't substituted in properly, because the motion that was filed to substitute them in was filed by somebody who didn't have standing, who had no business in the case.
I'll retain the rest for you. It's about a minute and a half.
Okay.
Good morning, Your Honors. May it please the Court, my name is Ellen Fornash. I'm here on behalf of the plaintiff appellee, MTGLQ. The issue at heart of this case is basically, does the Ohio Supreme Court mean what it says and says what it means when it issues opinions? The appellant's position is contrary to nearly 50 years of Ohio jurisprudence and practice. And yes, I do believe that this case centers fully on Civil Rule 25 and Schwartzwell. Rule 25 was adopted in 1970, and it clearly states that if the plaintiff's interest is transferred after commencement of the suit, Substitution of the parties is permissive, but is not mandatory. Later on, in the case of Krishbaum versus Dillon, decided in 91, the Supreme Court reiterated this principle. It wrote that substitution of the parties is not required following a transfer of interest in order to maintain the court's jurisdiction. So neither litigants nor the trial courts can err when they're following both the Ohio Supreme Court rules and the rules of civil procedure. Rule 25 does state in pertinent part that in case of any transfer of interest, the action may be continued by or against the original party. In Krishbaum, the Supreme Court interpreted this rule contrary to the appellant's position in this case. Specifically, the court wrote that substitution of the parties may be directed by the court, but that continued jurisdiction is not conditioned on that substitution of the successor party in interest. According to Shepard's legal citations, Krishbaum has since been cited over 350 times, and no subsequent case has disputed the validity of the Supreme Court's interpretation of the Civil Rule 25. Only one subsequent case has examined this issue, the case of Waterfall Victoria Master Fund versus Rittenhouse. That was the 5th District earlier this year. In that case, too, the appellate court followed Krishbaum and the plain text of Rule 25. After that decision, the Supreme Court did refuse to exercise jurisdiction to hear a discretionary appeal of the 5th District's ruling in Rittenhouse.
Counsel, I'm a little confused on what the difference between the First Amendment complaint and the Second Amendment complaint is.
Thank you for bringing that up. The initial complaint wasn't in fact sufficient on its face. A First Amendment complaint was done to correct typographical errors in the legal description of the mortgage. However, for the Ohio title standards, that legal description was sufficient to describe a property that was subject to foreclosure. It was amended a second time because Summit County Court of Common Pleas requires a property description approval form be submitted during the pendency of the case, and the county refused to provide that form to the plaintiff in the case until further error or typographical errors were remedied. So although the plaintiff would attest that the initial complaint was sufficient and did properly describe the property, it was because of this local form, this local rule that's required in a foreclosure action that the Second Amendment complaint was completed.
And so the difference between the complaint and the First Amendment complaint was the reformation,
Yes,
but then that was maintained in the Second Amendment complaint, is that correct?
yes,
And the Wagners answered the First Amendment complaint.
yes, but not the second.
Thank you.
I'd like to address the holding in Schwartzwald, if I could, because I do believe that the appellants are relying on a misinterpretation of that case. Rule 25 and Schwartzwald are not mutually exclusive. Schwartzwald only requires the plaintiff to establish as the holder of the note or the mortgage at the commencement of the suit. It says nothing about requiring substitution of the plaintiff when the transfer of interest occurs subsequent to commencement. It doesn't address that at all. Nowhere in its holding does it hold that any amended or supplemental complaints have to be filed in the current real party in interest. And nowhere in its holding does it state that a failure to substitute the plaintiff causes jurisdiction to be lost. Yet the appellants are making all of these conclusions based on Schwartzwald. The parties don't dispute that Fannie Mae, who filed the original complaint, had standing at the time it filed the original complaint. Therefore, this case is compliant with the holding in Schwartzwald. And again, as held in Krishbaum, the Supreme Court did instruct us that jurisdiction does not remain conditioned on substitution of a successor party. And it specifically stated that jurisdiction is not lost simply because a motion to substitute wasn't filed. I would also like to address the one case that the appellants rely on, BK Builders versus East Ohio Gas Company, because the holding in that case from 2014 is also misplaced. In that case, the appellate court does claim it's following Schwartzwald and rules that standing is determined, and I quote from paragraph 28 of that decision, at the time of the filing of the complaint. The appellants then seek to extend this to apply to amended complaints and supplemental complaints. But Schwartzwald didn't actually say that. Throughout the case of Schwartzwald, the Supreme Court said, and I quote again, standing is to be determined at commencement of the suit, end quote. They don't require standing to be determined at filing of a complaint. I believe this is a very important distinction. because commencement of the suit is critical, it's a critical event for determining standing, lis pendens, and thus jurisdiction. There's no question that the court did have jurisdiction in this case when the complaint was filed. Post-filing events do not and cannot divest the court of that jurisdiction. The same court later considered the Rittenhouse case, the 5th District. And in that case, they did find that Rule 25 was dispositive of the issue. 2 of the 3 justices that heard BK Builders also heard Rittenhouse. Rittenhouse is a more recent case, and it's certainly more aligned with Civil Rule 25 with Krishbaum than the BK Builders case was. So in effect, it's as though Rittenhouse almost overrules BK Builders sub silentio. One question that the appellants did ask in their brief, and I quote, "What is to prevent anyone from coming into a case and amending a complaint or otherwise prosecuting the suit?" But that's not really what the appellant's argument here is. They're not arguing that MTGLQ attempted to enter the case improperly. They're arguing that MTGLQ didn't come in soon enough. So I'm confused by that question in the appellant's brief. When it did enter the action, MTGLQ did provide the court with evidence of its standing and was determined to be the proper party by a court of competent jurisdiction at that time. The standing requirement of the civil rules is to protect the defendant borrower against multiple suits. Whether or not the substitution of the plaintiff is made once in a suit already filed in no way exposes the defendant to those multiple suits. In essence, today, I believe the appellants are not only asking for Schwartzwald to be extended beyond its original holding, but also to carve out an exception to Civil Rule 25 so that it no longer applies to amended or supplemental complaints. Civil Rule is unambiguous on its face, and it does not provide for exceptions. The Supreme Court said in Portage County Board of Commissioners versus the City of Akron, an unambiguous statute must be applied in a manner consistent with the plain meaning of its language, and the court cannot simply add or ignore words, end quote. If the original plaintiff has standing and can continue to prosecute the case even after an assignment of interest to another, there's no reason to conclude that the prosecution of the case would not include the continuing authority to amend its complaint with leave of the court. Because the substitution of the plaintiff isn't required at all, the assertion that the court lost jurisdiction or that the original plaintiff lost the authority to prosecute is directly contradicted by the plain text of Civil Rule 25. Therefore, we believe that the trial court properly applied Ohio law in this case when it did find that the plaintiff was the real party in interest when it filed this complaint and that it maintained the requisite standing at all times material to this action. And that is a quote from the judgment entry. For these reasons, the trial court's judgment should be affirmed.
Thank you.
Thank you.
Just a little bit of time.
Okay, in my brief time, I just want to go back to the argument that Schwartzwald is silent in regard to Rule 25C. And if 25C applied, then Schwartzwald would have been resolved on that. And all the cases that have come from Schwartzwald would be resolved under 25C. 25C just doesn't apply here. The issue is not the process of substitution. The issue is standing. Standing is fundamental. Standing goes to jurisdiction. Jurisdiction over the case. And if a party does not have standing, it cannot prosecute the case. It can do nothing in the case. It cannot file an amended complaint. It can't even amend, or it cannot even substitute a party. You read the dicta in Schwartzwald. It's fundamental. It's what the base. Jurisdiction is the basis of the authority of the court, and the basis of the jurisdiction is that the parties involved have to be the real parties. A case cannot be prosecuted by somebody who does not have an interest in it. And Fannie Mae did not have an interest in this case when it filed the second amended complaint and continued to prosecute this case, and even filing a motion for summary judgment, completely disregarding that it did not have standing in this case. It was just like anybody else in this. It had no interest in this case at the time it prosecuted. And the trial court was an error when it issued judgment on the complaint that was filed by a party without standing. What's clear on this? The court could do nothing but dismiss that complaint at that point. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. an initial written decision which we mailed to both sides as well as posted to our website and then to the Supreme Court.
Thank you.
Thank you.